Okay, we're now on the record with Wednesday morning civil docket for August 25th, 2021. Okay, Attorney Bill Garza.
Good morning, Your Honor. I have number 22 on your docket, which is CL 20-0636I, Robles versus Castro.
Okay.
And I'm here on behalf of defendant Elvira Martinez Castro.
Okay, and Mr. Denzer, I believe, is also on.
I'm here, Judge.
He is, and I did speak with Chris Sanchez. He is also plaintiff lawyer on this case. I spoke with him yesterday. He said I could make the announcement on his behalf as well. Your Honor, we mediated this case back in June. My counterclaim as a counter plaintiff portion, Nick Denzer was the defendant on that portion of it. That portion resolved. That's settled. So right now we are just finalizing a Medicaid lien that we think there may not be one, but we're still trying to verify that. I've sent some info to Mr. Denzer so we can resolve our portion. Chris Sanchez's plaintiff case, where I'm the defending attorney, that case did not settle. So that one just needs another status conference and a trial date whenever this court would like to do that.
Okay, so on that portion that did not settle, have y'all completed the discovery process?
We've done the depositions of his client, and I believe he did the deposition of my client already, but there may be a little bit left to do, experts, whatnot. So, I'd say another status conference, whenever this court would like, and then we can discuss trial date at that point.
Okay, and how far out would you be able to give me a good status?
I know you're resetting some of these cases for February for a trial status. I think that would be a reasonable time frame.
Okay. Well, if that's where we're headed, then yes, we'll go ahead and do February the 2nd.
Okay.
At 9:30.
That is it. And then as soon as Nick Denzer and I finish our portion, we'll submit the dismissal documents for the counterclaim.
Okay, and how much time do you need for that?
That one, hopefully within the next 30 days. I'm having some issues with Medicaid and some of the hospitals releasing information. I've gotten a tentative letter that I've sent to Mr. Denzer with the Medicaid lien, saying they don't have a lien interest in this case, but the medical bills show otherwise. So we're still trying to grapple with that.
Okay, I'm going to set a tickler for those documents for October the 1st.
Okay.
Just to check to see if they've been submitted, and if not, we'll follow up.
That'll work. I think that's all we have. Nick, anything else?
Thank you, Judge. That was a good update. Thanks, Bill.
Okay. All right, gentlemen. If nothing else, then you may be excused.
Thank you. Bye-bye.
Thank you. Okay, Ms. Hurtado?
Yes, ma'am.
Okay, you have your reaction button on, ma'am. What is your quick announcement?
No, it's just last time I was here, you told me to raise my hand.
That's right. Okay. F1202-21-9 in the matter of the marriage of Chenoa Hurtado versus Victoriano Hurtado. Okay, ma'am. Did you file your final divorce decree?
Yes, I did file it the last court date.
Okay.
We were just transferring the cases, so that's why you rescheduled it.
Okay. Ms. Rivera, do you see that the divorce decree has been filed and accepted?
Yes, Judge, it was filed July the 26th at 10:53.
Okay.
I'm sorry.
Okay, and Ms. Hurtado, your husband did file a waiver of service, is that correct?
Yes.
Okay. Give me a minute and I'm gonna pull up your petition here.
Okay.
Okay, Ms. Hurtado, please raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God now?
Yes.
Okay. Please state your full name for the record.
Shanoa Hurtado?
Okay, and you are the petitioner in this divorce, is that correct?
Yes.
And you filed this petition for divorce on March 19, 2021?
Correct.
And your husband executed a waiver of service that you had filed on March 24th, 2021, is that correct?
Yes.
Okay, and you and your husband have entered into an agreement with respect to the issues in this divorce, is that correct?
Yes.
And that has been submitted in a divorce decree that was filed with the court, is that correct?
Yes.
Okay, ma'am. Then at the time that you filed for this divorce, were you a domiciliary of Texas for at least 6 months and a resident of Hidalgo County for at least 90 days?
Yes.
And ma'am, are you asking the court for a divorce today because your marriage has become insupportable because of discord or conflict that prevents the legitimate ends of this relationship?
Yes.
Is there any reasonable expectation of reconciliation at this time?
No.
Okay. Did you and your husband have any community property?
No.
Did you and your husband have any community debt?
No.
Okay. And you were married on or about December 28th, 2012, and stopped living together as husband and wife on or about March 1st, 2021. Is that correct? Ma'am?
Yes, that's correct.
Okay, you need to answer or it won't be on the record.
Okay.
And you and your husband have 2 children,
Yes.
and that is Claudio, who was born on November 5th, 2013, and Castiel, born on July 22nd, 2016. Is that correct?
Yes.
And are you expecting a child of this marriage at this time?
No.
Okay. And you and your husband have entered into an agreement with respect to child support and visitation?
Yes.
And your husband will be exercising what type of visitation, ma'am?
Every first, third, and fifth weekend.
Okay, so then he will be having standard
Correct.
visitation.
Yes.
Okay. And what about child support?
Yes, we have a child support order as well.
Okay. Do you have the case number for that child support order?
I believe you merged it into, or you requested it to be merged into this case.
I can't request it to be merged, ma'am. You would have to ask for it to be consolidated. You would have to file a motion to consolidate that and attach an order. I'm reviewing your divorce decree and you don't have anything with respect to visitation or anything with respect to child support.
I have the cause number for the child support order if that's what you
Okay.
need.
Well, go ahead and give me that cause number.
Okay, give me one moment, please. I'm sorry, I wasn't prepared.
I believe what I did the last time was that I ordered on the record, I granted your oral motion to consolidate.
Yes.
And so you were to submit an order consolidating them. And then you have to, I don't know if you recall that I told you had to attach it as an exhibit. So you have to update, you have to file an amended divorce decree and attach it as an exhibit. But if you can give me that cause
Okay,
number.
because I have the cause number now, unless I still need to do that.
Okay, give me the cause number.
Okay, it's F-3970-18-4.
Okay. So I think that what I stated was that we were going to submit an order of transfer so that that case could be transferred to our court. I don't think that's been done yet. So that needs to be done first, and that's from our part. So
Okay.
my staff needs to file an order of transfer on that cause number, have that transferred into our court. Then what you need to do, since I granted your order, then you have to file an order to consolidate.
Okay.
Okay, however, my court coordinator is informing me that that was disposed of. Now, was it, Ms. Rivera, was that disposed of in the form of a drop docket? Or was it just closed because it was finalized?
It
Because
was
that's two
fin-
different things.
Yes, ma'am, it was disposed of in a form of, it was finalized in 2018.
Okay, that still requires us to do an order of transfer. So, but you have to do, Ms. Hurtado, your order to consolidate.
Okay.
I can't tell you how to do it.
Mhm.
You would have to look up that form.
Okay.
And you're gonna be consolidating that case into this one. And then you have to attach that order that has been a final order since back in 2018 to your divorce decree. Are you
Okay.
asking the court to adopt the order in cause number F3970-18-4?
Yes, ma'am.
Okay. So if everything's going to stay the same with respect to child support and visitation, that is fine. The court will adopt it and we'll go ahead and allow it to be a part of this, but you do need to submit that properly. So I'm going to I took your testimony today for what we call a prove up. However, you are not divorced.
Okay.
So I'm going to give you 30 days to do that. So I'm going to bring you back here for a status on that. On September the 29th at 9:30. So it needs to be done by that date, okay?
Okay. All right. Thank you, ma'am.
Okay, ma'am. If nothing further, you may be excused.
Okay. Thank you.
Okay, Attorney Felipe Garcia. You're on mute, Mr. Garcia.
Beg your pardon, Judge. I'm on number 20, 194689-I. I'm not sure who's here for the other side or anyone is.
Okay, is anyone here for the defendant, Stephen Healy or Jane Beakey? Who do you have as the attorney of record, sir?
Judge, I beg your pardon. I just checked the office about 10 minutes ago to find out who was going to be here. And I don't know who it is. I couldn't find it on my emails. I think it's Farmers Insurance. I'm not sure though. Judge, I can tell you, they've been asking for a mediation, and that's what we're going to do next is mediate this thing. Hopefully something comes of it.
Okay, but do you know who who opposing counsel is to mediate with, or?
Your Honor.
No, I'm sure we can come up with somebody, I'm sure, very quickly.
No, I mean, go ahead, Ms. Rivera.
Judge, on the last hearing, there was not an announcement from the defense counsel. However, in the emails for an order setting hearing, it was to Mr. Damon Garcia with Farmers Insurance.
Okay.
That's who it is. It's Damon.
Okay, so have you already concluded your discovery process?
No, not quite yet, Your Honor. I have not taken the deposition of the defendant. And that was mostly just to try to save costs, see if this thing gets settled. I mean, the guy plowed into her from behind at the stoplight, so I just didn't feel like it was urgent for me to take that deposition unless it doesn't settle and then it goes forward.
Okay. I'm gonna submit an order of referral to mediation, so y'all can mediate this within the next 90 days.
Right, ma'am.
And then, I'll have you come back on December the 1st at 9:30 to see where we're at.
Well, it's a good thing that the Cowboys probably won't be in the playoffs, so it shouldn't have any conflicts from my schedule.
Oh, don't say that. My husband will be crying. He says they're gonna make the Super Bowl every year. So they'll still be playing. I think they have games through January. I should know because we have to write the games on the calendar and we work our mass schedule around it. So that's horrible. As a matter of fact, our priest said last week that people will leave the church before they will leave the Cowboys. That's the loyalty. That's how loyal people are to the Cowboys.
If they don't win, they can always make the Super Bowl cereal, Judge.
That's a good one. Okay, well, we'll see you back here on December the 1st at 9:30 and we'll have an order of referral sent out to you.
Thank you, Your Honor. That'd be excused.
You certainly may, sir.
Thank you. Bye-bye.
Okay, Attorney Ruben Medina.
Good morning, Judge. Here on number 17 on the docket, that's CL 19-0286-I. Here on behalf of the plaintiff, Teresa Valdez.
Okay, sir, and anyone here on behalf of the defense?
Yes, Mr. Denzer is here for the defense.
Okay,
Judge, this is a case that the insurance company went into, I guess, receivership and liquidation. So there is a company or through TP SIGA that is taking the claim on. They have all the information to my knowledge. So they are assessing the claims. That I just hear that there is a large number of claims that they are assessing per adjuster. So if we can have maybe 60 to 90 days for a status, and then we can take it from there to see where the adjuster is on that.
okay, Mr. Denzer, anything to add?
That's correct, Judge. The only thing I noticed, I don't know if we need to file an order granting our motion to substitute. It was heard, I think, over the summer, but I don't know if file an order or if that's something you guys just order a
Okay.
substitution on.
No, if you have, you need to file your order granting. I'll grant it on the
Okay.
record, even if it's an oral motion. But just because if not, they will not update the attorney on the clerk side.
I think the order was.
Okay,
filed.
we filed the motion, we had the hearing, I think.
Are you
Okay, I
just
don't
sending
think
the
we filed an
order
granting.
granting?
I
I'm
think
sorry.
so, and I think we can file one today.
Okay, just file an order granting. I'll have it forwarded to my queue. Okay, go ahead and come back on December the 1st at 9:30.
Yeah, to confirm, was this the Jose Trevino case?
No, this
Okay,
is
never mind.
Teresa Valdez versus Jose Mateo Rodriguez.
Okay, might be the same issue with the receivership of the insurance company. Thank you.
Okay,
That's all I
Okay.
have, Your Honor.
okay, Mr. Denzer, do you have any other case?
I have one more case, but I'm on my phone, so I can't tell if the other attorneys are here. It's number 23 on the docket.
Okay, Mr. Medina, then you may be excused, sir.
Thank you, Judge. Have a great day.
Likewise. Okay, that's CL 23669-I, Roberto Moreno versus Frank Mukete, Mukete. And I have Attorney Rafael de la Garza for the plaintiff.
Present, Your Honor.
Okay, and what is the announcement, gentlemen?
Judge, I think this is a similar issue to the last case. The last case where there's a receivership or liquidation. So we're kind of at a standstill based on that issue.
Okay,
Good
Ms.
morning.
Orellana. Okay, go ahead, Ms. Orellana.
Yes, Judge, good morning. I'm here for Juan Esteban Ruiz in the plaintiff's capacity. That is the case on this one. However, I have been reaching out to all parties in order to move forward on this one. It's my understanding that there's information pending even from my client. However, I haven't received that document. The last time that we were here in court, it was the same issue. So I'd request from the court if there can be some sort of deadline or something so we can move forward, because that's the holdup right now. We can't move forward with depots. We can't move forward with mediation because I'm being told that that information is needed.
Well, did you all conduct discovery?
Yes.
So if you have discovery, then those deadlines are automatically set. So did they has that already, then the discovery, you can supplement still, but I mean, if I set a deadline for supplementing, then it's like doing a scheduling order. And
my apologies, Judge. I think one of them is an affidavit from the plaintiffs, from both plaintiffs, in order to let them know that there is no additional auto insurance on the case, no UIM or anything like that, because it is in receivership. I haven't received that document so that I can provide them the information. By affidavit, we don't have UIM for my client. But Nick is telling me that there's a document that they need. They haven't given me that document so that we can move forward with this case.
Judge, the plaintiffs provided the information that needed to, as far as the auto insurance they had at the time of the accident. I don't think we need any information from Mr. Ruiz, who I represent, and Ms. Orellana represent. I don't know if anyone's here for the co-defendant, the Muquetes. But I'm moving forward with depositions in this case if everyone else wants to.
okay, Mr. De La Garza, I mean, this is your lawsuit.
Judge, we're the plaintiffs. I think there was an intervener for Ms. Graciela Orellana. I've requested deposition days from the attorneys representing the Muquetes. I have not received any sort of response from that, and I don't see them here this morning. And my client has, through me, submitted all the responsive documents, unless Mr. Denzer corrects me if I'm wrong. All the responsive documents related to the receivership or liquidation have been submitted already for my client, Mr. Roberto Moreno. So we're ready to proceed to depositions, Judge. And we, unlike Ms. Orellana's client, I think we're done on the liquidation issue.
Okay, so
and
then
I don't think we need anything.
Okay, so you all can proceed to work the case then.
Correct.
Okay, and so when would you all be ready to mediate it?
We can be ready for depositions as soon as Mr. Denzer, maybe within the next 30 days, Judge. And I would suggest mediation in the next, before the next maybe 90 days or 70 days from now.
Judge, as far as availability for depots and mediation, I don't have anything available until probably November. I have my calendars for September and October full.
Okay, so then, let me see. Well, how about mediating it by the end of the year, by December 31st?
That's fine, Judge.
That's fine with me as well.
Because if you're full and then you get them in for November, I mean, that should give you plenty of time to have all the information you need for mediation to occur in good faith in December.
That's fine, Judge.
Okay.
Yes,
I can see if the end of December works. The only tricky thing with these cases is they have to do everything by statute before they can get settlement authority. But we're ready for depositions, even though we're missing a couple things. The adjuster said we can take depositions, but we can put that as our date, and then if I need to request more time from the court for mediation, I can do that.
Okay, that's fine. I mean, it sounds like all three of you want to move forward, so I guess we'll see if you really, if your actions will speak the same language as what you're saying right now. So We'll go ahead and send out an order of referral to mediate this by December the 31st. And in the meantime, just continue to work your case, and I'll have y'all come back on February the 2nd to give me a status at
Okay.
9:30. That way, if you do not settle for whatever reason, then maybe we'll be ready to give you some dates for trial.
Okay.
Okay?
Yes, Judge.
Okay, anything else on this case?
Nothing further.
That's
for the
it.
previous judge.
That's it.
Okay, do any of you have any other case?
I have nothing further, Your Honor. May I be excused?
You certainly may, ma'am.
Same announcement for me.
Maybe
Judge.
excuse as well.
Have a good day.
Okay, yes, all of you may be excused then.
Thank you.
Thank you. Attorney James Cuellar?
Yes, Your Honor. This is number 24, and the case number is CL 21-1711 dash.
I got the notice of federal
I don't know
tax.
if it's an I or a 1.
And I noticed that the
Okay, hold on, I just muted somebody. Okay, that's CL 21-1711-I. Gem Enterprises LLC versus WBLSPE 3 LLC. Okay.
Yes, Your Honor.
so-
Our announcement is we did go to mediation last week on, I think it was the 17th. Yeah, Tuesday, the 17th. We did not settle the case, but we agreed then that we needed more time to try to conclude the mediation. The mediator has graciously agreed to continue the mediation. And right now we're in the process of trying to get that rescheduled. And I should have said, Your Honor, at the outset of this, that I got an email from the plaintiff's counsel, Kelly McInnes, telling me that he was going to be in another hearing this morning, but he authorized me to make an announcement that that I just described, that we are still working with the mediator, Alfred Denham, to continue the mediation. And we're looking to try to get that continuation set for next Thursday, September the 2nd. So if we could roll the status conference to sometime mid to late September, that would be great.
Okay, September 29th at 9:30.
September 29th at 9:30.
Yes, sir.
Okay. Thank you, Your Honor.
Yes, sir. Okay. Attorney J.R. Garza?
Your Honor, I'm here on a P case on P 0178199, Judge.
Okay, Jasmine Reyes versus Eric Garza.
Cynthia Martinez for the applicant and the state. Hello.
Your Honor, I can make an announcement on this. We are really close. We thought we were ready, but there's one little caveat that we have to add to the order that we are currently talking to the DA's office about.
Right.
So we would like a very short reset so that we can get a confirmation from the DA that they can put a little exception in there so we can resolve the entirety of this matter.
Okay, Ms. Martinez, anything to add?
Well, the applicant had surgery today, and I don't know what kind of surgery, so I would like to make sure she recovers enough so that I can talk to her about the point that Mr. Garza is talking about.
Okay, so how much time are you requesting?
Judge, may I speak about the point real quick? I'll make it very short, because I think it's important that we understand what point we're talking about.
That's fine.
Judge, basically, the gentleman has two kids, one with the applicant and one with another woman. These two kids that he picks up and drops off sometimes when his wife is not available. Sometimes the applicant is at the same school dropping off one child or picking up one child on her extended weekends. And so he is also in the same school picking up his child doing his parental duties. But I've asked the DA's office to consider an exception that if it is a serendipitous running into her while he's doing his parental duties, that there be an exception that he not get arrested because he's on the same campus within 200 yards. It's a pretty reasonable request, I think. And then if we can read that into the record and have it in the order, then we'd have a complete agreement.
Okay.
He's a peace officer, by the way, Judge. He himself is a peace officer.
Okay, well, I'll allow Ms. Martinez time to speak to her, to the applicant, but I just need to know how much time.
Can we have at least 2 to 3 weeks, Your Honor?
I
Okay.
have no objection to that, Your Honor.
Okay, how about September 15th?
Thank you, Your Honor. I think that's fine.
A day before my birthday. Just remember my birthday, Your Honor.
Okay, so September 15th at 9:30.
Thank you,
Okay,
Judge.
thank you, Your Honor.
Okay.
Maybe
thank
excuse, Your Honor.
You certainly may.
Yes,
Thank you.
thank you. May I also be excused, Your Honor?
Yes, ma'am.
Thank you.
Yes. Mr. McInnes, Mr. Cuella made the announcement for you on your case.
Thank you, Judge. Wanted to check in with you, make sure that announcement got made, but I was in Willacy County Court here just a minute
Not
ago.
a problem. Not a problem, sir.
Thank you, Judge. May I be excused?
You certainly may.
Have a great day. Bye-bye.
Likewise. Okay, Attorney Lucy Williamson. You're on mute, Ms. Williamson? Yes, ma'am.
Thank you.
Yes.
Your Honor, I don't know if you called my case. I'm having internet problems.
Oh, join the club. Yes, I did. I just called your name. I don't know.
Thank you, Your Honor, and I apologize, things cut in and out. I have this morning F 3136 13-9. I represent Adolfo de Leon. We were previously set in July. The respondent did not show up. She has not showed up again.
Okay.
So
And
we're
what is the respondent's name?
The respondent's name is Elva Aurora Villarreal.
Okay, Mr. Damian, can you please call out that name 3 times?
Yes, ma'am. Erica Villarreal. Erica Villarreal.
Elva. It's Elva.
I'm sorry. Elva Villarreal. Elva Aurora Villarreal. Elva Villarreal.
Okay, the name has been called out 3 times. Let me just check here.
No, she never.
Do you have any problem with that? I mean, you want to supervise, right?
Yes, until she gets a test.
I just tended to Davis.
Okay, and Ms. Williamson, do you know if she had notice of today's hearing?
Yes, Your Honor, the order setting hearing that was submitted had her email address at a Gmail account.
Okay.
Judge, if I may,
Yes.
I know that she had notice for the hearing in July, but I don't believe there was an order that was signed or an order submitted for signature for this particular hearing. She did have counsel, the counsel withdrew, but from July to August, Judge, I don't see any order resetting that was filed.
I don't see it either, Ms. Williamson, that there was an order resetting hearing for today, giving her notice of today's hearing.
Your Honor, we did submit one. We'll resubmit one. She wasn't, even when notified, she did not show up.
I understand, and she probably won't show up.
Yeah.
But just so that we can be in compliance with the rules of civil procedure, if you can submit an order resetting hearing, making sure that she is CC'd on that, and I can give you just a quick reset date for September I don't know if you'll get it back fast enough for the 1st, but we can do it on the 8th.
September the 8th, same time, Your Honor?
Yes.
September 8th it is.
At 9:30, and if you'll have that put on the order resetting hearing, and then we'll sign off on it.
Yes, Your Honor. Thank you very much. We have nothing further. We can be excused.
Yes,
Thank you.
yes. Okay, Attorney Rolando Cantu.
Good morning, Your Honor.
Good morning, Judge.
This is a quick announcement, Your Honor. My client is still in bankruptcy, as I understand it, and I've tried to reach out to the other attorney for ER funding, and he has yet to respond to me. So we are continuing. So if the court would be so gracious to give us a reset date, we'll continue working and let the court know. But we are in bankruptcy, so everything is stayed. So.
Yes, sir. Okay, that's CL 162175-I, Mission Vacuum and Pump Truck Services versus Texas ENP funding. Okay, so then how far out? Well, if he's still in bankruptcy, that's still going to be a while.
Yes.
Okay, let's come back on February the 2nd and let's see where we're at.
Very well, Your Honor.
And that'll be at 9:30.
Very well.
Okay,
Thank you very much. I have nothing further. May I be excused?
you certainly may.
Bye-bye. Have a great day.
Likewise. Okay. Okay, Attorney James Zahadi.
Yes, good morning, Your Honor.
Good
Here on
morning.
number 9 on the docket, that's F-1559-21-9. Judge, we're here on a motion for substitute service of process. We had tried to serve the respondent by personal delivery, but the affidavit of the process server indicated that no one there lived, that no one by that name lived there. However, my client, who is present with me today, has indicated that he reached out to his daughter, and she in fact did assure him that the respondent did in fact live there. So we're either requesting one of two things, judges. One is the parties have been separated since 1994, 27 years. There are no minor children. There is no property. We believe that service by publication by posting a citation would be appropriate pursuant to Texas Family Code 6.409 subsection D, or if the court prefers, we would respectfully request that service be had by providing the service of citation to anyone over the age of 16 at that address.
And you attach the affidavit. Because the affidavit that I see is the one that has your.
Yes, Judge. I can go ahead and draft an affidavit. If the court would sign off on the citation by publication, I would be more than happy to file an affidavit that would comply with subsection D of 6.409.
Okay, so the affidavit that was filed by the civil process server stated that no one by that name lived there. However, the daughter of your client states that she does live there, and that's
Yes.
her knowledge.
Yes, she had initially indicated that that's where they lived, so that's why we tried to attempt service there. When the process server came back and stated that no one lived there by that name, we again, my client reached out to his daughter, and she did assure him that she does in fact live there. So I don't know whether she's trying to avoid service or wants nothing to do with him. We just don't know, Judge.
Okay, so then you're gonna Well, what you can do is file an amended motion for substitution of service and attach her affidavit stating that she has personal knowledge that her
But-
mother does live at that address.
Judge, the relationship between my client and his daughter, she won't sign off on an affidavit stating that, Judge.
Okay. So how are you gonna, I mean, I know that she says that the mom is there. But you need something on file or something so that you can support that argument so that you can leave it there. If you have something that states that you don't know her whereabouts, and then you can do your citation by publication, or that it's uncertain that she lives there.
I do have my most recently amended petition, the third amended, does assert that we do not know her whereabouts, Judge.
Because of the conflicting information that you're receiving.
Yes, ma'am, exactly. And again, because the parties have been separated for over 27 years, no property, no minor children, we would respectfully request that the court allow us to, what I feel would be best would be the publication by posting.
Okay. I'll go ahead. I'm going to grant your motion for substitution of service, allowing you to do a citation by publication, submit an order to that effect. Also,
Yes, ma'am.
you'll also need to file an order to appoint an ad litem for her in case she doesn't respond.
Judge, my understanding is that there's no appreciable property, no ad litem would be needed. I would respectfully request that no ad litem be appointed because of the costs involved with that.
Well, part of what the ad litem does is to make sure that the service was attempted and that the person is not going to be harmed. I understand that they're not going to, that they don't have any property or anything like that. And it's been a long time since their separation, but I'm requiring that ad litem to be appointed. So it should be minimal cost.
Yes, ma'am. I will go ahead and do that. I'll go ahead and amend the motion for substitute service to include the language that's required by subsection D then.
Okay.
And I'll follow the appropriate orders.
Okay, so get those orders filed and submit them to us, and then we'll go ahead and have that forwarded to my queue for signature so that you can do your posting.
Thank you, ma'am.
Okay, so then I'm gonna give you, that should take you a bit, so I can give you a status hearing just in case everything goes through properly so that you can finalize it. You can change the status to a final hearing at
Yes,
that
ma'am.
time. So let me see. We can come back on October the 6th. You think that'll give you enough time to publish it?
Yes, ma'am. We'll get on it right away.
Okay, so October the 6th at 9:30.
Thank you, ma'am. May we be excused?
You certainly may.
Thank you.
Okay. Mr. Gutierrez, the bench trial that you have set, is that one that we have at 11?
From my paperwork, it shows that it was supposed to be at 9:30, Your Honor.
On my docket, is it Capital One versus Justin James?
Yes, Your Honor.
Okay, I have it on my docket at 11 a.m.
Of course.
in about 40
I'm
minutes.
local counsel. All right. Well, that would explain why Mr. Haberman is not here, and I am. So.
Okay.
All right. Well, then, do I use the same Zoom ID or?
Yes.
Okay. Thank you, Your Honor.
Okay, we'll see you then. Okay, Attorney Mauro Ruiz.
Good morning, Your Honor. I'm here on behalf of Mr. Shakeen on a status conference. I do not know the last action on this court was several months ago where the court granted Mr. Tuttle's motion to withdraw his counsel. And I think he was expecting someone to take over. I haven't seen any document to that effect though. And I don't know who the client would be for this South Texas Educational Technologies Horizon Montessori Public School would be.
Okay, so that's CL 173055-I, Mr. Shaheen versus South Texas Educational Technologies, Inc. et al.
That's correct, number 16, Your Honor, yes.
Yes, okay, and is there anyone here on behalf of that defendant? Okay, so Mr. Ruiz, no one has contacted you with respect to substituting?
Correct, Your Honor.
Okay, so, I mean, do you plan on continuing to work up the case so that you can move forward on it?
Yes, Your Honor, I was just, I was being patient. I was trying to give the school or the defendant an opportunity to retain someone, but I have to follow this court's rules and what the court wants, so.
The court wants it off its docket, no.
I was trying, I've been trying, Your Honor, to get some traction going the past year, but I've been slowed down.
I understand. I would say, Mr. Ruiz, I mean, obviously, I'm not going to tell you what to do on your case. I mean, I don't think you're going to have a choice but to move forward with anything that you have to continue to move your case forward. And if they get somebody, they get somebody. And if they don't, they don't. But they have had a lot of time to find someone in the interim. And you're correct. You have been very patient. So, I mean, what I can do is I can set you for a status just to see if anything has happened. And of course, in the meantime, if you file anything, we'll get it set for you so that you can move forward with it. But I mean, let's see where we're at on October the 27th.
October 27th, at what time, Your Honor?
9:30.
Perfect, Your Honor.
And just keep pushing forward, I guess.
I will, Your Honor. Thank you for
Okay.
your patience on this matter. Maybe it's-
Absolutely. Have a good day. Okay, Attorney Sergio Munoz Jr.
Judge, good morning. I have number 12 on the docket, Judge.
Okay, that is CO 153093-I, Luri Alejandro Duarte et al. Versus Jose Luis Soto et al.
Yes, Judge, I represent the plaintiffs, Your Honor. The Duartes, I think Joe Reyna is on Zoom and he represents the defendants, Judge.
That's correct, Your Honor. Joe Reyna for Jose Luis Soto.
Okay, and what is the status on this case, gentlemen?
Judge, I guess I'll just work with Mr. Reyna. I know there's some discovery that's outstanding that he needed to respond to. And hopefully I can get that information in a timely manner, and then I guess be able then to file my appropriate motion with the court as to whether we want a bench trial or any other type of disposition.
Okay, Mr. Reyna, any additional announcement?
No, Judge, I believe I can resubmit the discovery. I thought I had already done it. Maybe I haven't in such an old case, but I'll resubmit it's some correspondence. I believe that's what he wanted from his client to mine. But if you can, I don't know how much time, Judge, you want to give us, maybe something in October. I'll get him something by the end of this month.
Well, why don't we go ahead and come back on October the 27th, and that gives you all about 60 days to see how you're coming along.
Very well, Judge. And I think there's a DWAP setting on this case. It's so old, coming up here in a few weeks. Can we take that one off the docket?
Yes, we'll take it off the docket and we're going to retain it, and we'll have you all come back on October the 27th at 9:30.
Thank you, Judge.
Okay, anything else?
That's all we have, Judge. May I be excused?
You certainly may.
Thank you. Have a good day.
Thank you, likewise. Okay, Attorney Pete Espinosa.
Communication. Good morning, Judge. Peter Espinosa, on the case number F3808-18-9.
Yes, sir. In the matter of the marriage of Blanca Garcia Gomez and Rene Guillen.
Yes, if I may. Mr. Opposing counsel, Mr. Hinojosa, and I have agreed to reset the case with the court's approval. We signed a Rule 11, but it has not been submitted to the court. So we're asking.
Oh, can you please stop? I just got a message that my court reporter lost internet. Hold on. Let me give her an opportunity to log back in. Miss Garza, Alma Garza. Alma Garza.
Alma's been with us for a long time.
Let me call her on her phone.
Yeah, Alma.
Let me call her on her phone. Hold on.
Alma. She's got it.
Okay.
Alma. Okay, turn up your volume. Alma, can you hear me?
Yes, Judge, I'm waiting for the other attorney. He's in another court, and I'm in another court.
Okay, that's what I was gonna tell you, that if you both happen to come on before 11, let me know.
We will, Judge. Thank you.
Okay. It said I saw that Mr. De La Mora was working and that way he could get back to work. Okay, whenever you're ready, as long as both of you are on, I'll take you. Okay, let me just double check. Ms. Flores, are you back connected?
Yes, I'm back, Judge.
Okay, let me go ahead and we'll back on the record on F3808-18-9. Mr. Espinosa, you were stating that you and opposing counsel had agreed to reset the case with the court's approval, sir. Is that correct?
That's correct, Judge.
Okay, and are you all still talking?
Oh, we are. We're actually, we have a informal mediation set and a formal mediation, I believe, but I think we can resolve it.
Perfect. Okay, how much time are you requesting, sir?
30 days to 45 days, I think we can get it resolved.
Okay, I have September 20th or October 6th.
October 6th.
Okay, and that'll be at 9:30.
All right. I have nothing further, Judge.
Okay, then you may be excused.
Oh, would you like us to submit the order resetting?
No, you're on right now, so we'll go ahead and put you on the docket, but you won't receive any further notice.
Okay, thank you, Judge.
Okay.
Can I get
Attorney, yes, sir. Attorney Diana Fuentes Aguilar.
Judge,
Good morning.
Oh.
I don't know if you're still taking quick announcements. This is a request for a TRO, temporary orders. And I believe the opposing party is here, but I don't believe he has a lawyer unless he advises otherwise.
Okay, that's F3716-21-9 in the matter of the marriage of Elizabeth Hernandez and Marcos Martin Hernandez Garcia. Mr. Garcia, are you present? Or Mr. Marcos Hernandez, are you present?
Yes, ma'am.
Okay, sir, can you please turn on your camera? Okay, Mr. Hernandez, we're here on temporary orders. There was a restraining order that was signed back in August, on August the 13th, sir. Will you be retaining counsel to represent you?
No,
You're going to be representing yourself?
yeah.
It's yes, ma'am, or no, ma'am. I'm sorry?
Yes, ma'am.
Okay, so you will continue to be pro se. In other words, represent yourself.
Yes, ma'am.
Okay, let me remind you that if you represent yourself, you're held to the same standard as if you were an attorney. Therefore, you're responsible for continuing to communicate with opposing counsel. So you have to be in constant contact with Ms. Fuentes Aguilar, respond to her if she calls you. so that you can try to seek a resolution on this matter. So Ms. Fuentes Aguilar, are you requesting an extension on this?
Your Honor, I'm ready to proceed. My client is going to be moving out of the home really soon. She's trying to move out soon, and I think.
Okay, have you had a chance to talk to Mr. Hernandez?
I have not. That's.
Okay,
no.
so, I mean, if there's an agreement, I'll allow you to proceed, but if it's contested, I have four other contested matters. So
Your Honor, I don't know if Mr. Hernandez could share his phone number with me, and I can try to call him while we're on, and then I can make an announcement.
I can also put you in a breakout room if you want to take advantage of him being here. For all you know, maybe if you give him what your proposal is, he may be in agreement with it.
That's fine, Your Honor, that'll work.
Okay, let me go ahead and do that. Mr. Hernandez, you're gonna see an invitation on your screen to join a breakout room. And I need for you to accept it as soon as it comes on, okay?
Okay.
Okay, did you happen to see that on
No,
there?
no, I didn't see anything, Your Honor.
I didn't get anything either, Judge.
Okay, let me see. How about there? Mr. Hernandez, did you see it? Okay, there, he did. Okay, we're gonna continue with the docket. Attorney Juan Ramos.
Hi, good morning, Your Honor. I'm here on number 5 on your docket.
Okay, that's F 3461-20-9 in the matter of the marriage of Cynthia Cardona versus Jose Cardona Jr.
Yes, Your Honor, Juan Ramos here on behalf of Mr. Jose Cardona. Your Honor, we're pending arrearages at the last hearing. We provided information to the Attorney General's office, informing them that Mr. Cardona didn't have any wage information. He was unemployed at that time. So I believe they're going to compute the arrearages based on that.
Okay, Mr. Sanchez, are you here on that case?
Yes, Your Honor. Adrian Sanchez on behalf of the AG's office, Your Honor, on that case. We're still working on that issue, Your Honor, since we have limited wage information in this case. We have not had an opportunity to discuss it with the mother. I think she's the petitioner of the divorce. It's a divorce.
Okay, Ms. Cardona, Cynthia Cardona present?
Yes, ma'am.
Okay, so Ms. Cardona, the Attorney General's office needs to speak to you with respect to the arrears issue. So whenever they call you, please be available for them because that issue needs to be resolved before you can proceed on your divorce.
Okay.
Okay, so Mr. Sanchez, how much time are you requesting?
Your Honor, we just need a short reset just to get all the figures down and see what probably the parties could agree for a final order.
Okay, like a 2-week reset or longer than that?
I think that should be doing unless I'm not sure Mr. Ramos needed additional time.
No, 2 weeks is fine for us as well, Your Honor.
Okay, September 8th at 9:30.
Okay, that sounds good.
Okay, anything else?
Thank you. Nothing further, Your Honor, on this case.
Okay, Mr. Ramos, any other case?
Nothing further, Your Honor. May we also be excused?
Yes, and Ms. Cardona, you may also be excused.
Thank you.
Okay, all right, Attorney Ruben Ramirez.
Good morning, Your Honor.
Good
Ruben
morning.
Ramirez on behalf of the defendant. This is number 18 on your civil docket.
Okay, that's CL 192570-I, Jose Manuel Banderas et al. Versus Samuel Rangel.
Good morning, Your Honor. Rui Mireles, I'm here for the plaintiffs.
Okay, and what's the announcement, gentlemen?
Your Honor, so this has a particular sticky situation where there's a potential witness that we wanted to depose. We had difficulty in trying to locate her. She has pertinent information, especially with regards to the contested issue of damages, right? And so we hired a private investigator to go out and try to make contact. Now, we were able to make contact with her daughter, and her daughter had informed us that the mother, the potential witness, is actually mute. And she does not know sign language because she didn't have that opportunity to learn sign language. So this is all pretty recent developments. So that kind of negates the way she's able to communicate with people is by reading their lips. And even then it has to be slow, and it's kind of not a perfect science, so to speak, the accuracy. So that's the hiccup we're running into right now. As we believe it would be something that would need to be done in person. And now there's the whole COVID thing. And so we try to be sympathetic to, to potential witnesses, concern regarding that. So that's kind of where we are with that. We have tried to mediate this case originally before speaking with the witness. We weren't able to come to, to terms. We're kind of far off, but that's where we are, Your Honor. That's our announcement.
Yep.
So we would need additional time.
And also the defendant driver's depot is also pending, so we need to also do that as well. So I know that written discovery we've already completed. We do need to take the defendant driver's deposition. I'm assuming we're also going to take probably some expert depositions, and then once we're done with that, I think we would be ready for a trial date.
Okay, so how much time do y'all need to conclude your depositions and try to overcome this obstacle, Mr. Ramirez?
Your Honor, I would hate to give a realistic time frame because the court might not like it, but
no, give it to me.
I'm thinking probably 6 to 8 months because I know I'm also it's going to be difficult because we need to do it in person, and who even knows if it's going to be able to come out right. But we're going to give it our best shot.
Okay, if it's fine with y'all, if it's not too far out, we'll come back on February the 2nd, and let's see where we're at by then.
Okay.
I'd rather have realistic than to have you guys come back sooner and me not like what you have to say.
Yeah, we don't want to be like the Cowboys and have to punt every down, right? So I'm just kidding. Super Bowl this year.
That'll be off the record, Lisa.
Yeah.
You know, any Cowboys that cut down will be off the record.
I know. All of a sudden, I start seeing all these attorneys start clicking their video cameras on.
Ruben, what's gonna happen is you're gonna make the people watching on YouTube comment all this hate stuff on you.
I'm sorry, Your Honor. I'm kidding.
No, I'm just joking. I'm just joking. No, I know. A Cowboy oh my gosh. I always dread football season because the optimism, and then it's a roller coaster of emotions.
It really is. It really is.
But anyway, okay, then we'll see y'all back here on February the 2nd at 9:30.
9:30.
Okay, do y'all have any other cases?
No, Your Honor. That concludes my business with this honorable court. May I be excused?
You certainly may.
Thank
I'm sorry, Mr. Mireles? Yes,
That's it.
you certainly may.
Thank you.
Take care, Ruth.
You too,
Ms.
Ruth. Take care.
Fuentes Aguilar, were you able to reach an agreement?
Your Honor, yes, mostly. There's only one issue, which is it's a brief issue. It shouldn't take more than 3-4 minutes to proffer to the court. And other than that, we're agreed.
Okay, well, he lost connection, so hopefully he'll get back.
I told him if that happened to get back on, and I'd wait, Judge, because I know that seems to.
Okay. All right. I'm sorry, Mr. Sanchez, Adrian Sanchez, which other case are you here on?
I'm here on the case with Mr. Cavazos. It's under F30. F 4922-19-9.
Good morning, Your Honor.
Good
Jaime
morning,
Cavazos here
sir.
for Mr. Abraham. Yes, he's available. He's got
And
his video off, but
who is the mother?
I am Nicolas Villarreal.
You're having some trouble with your audio. Okay, so Ms. Villarreal, are you still representing yourself?
As of the moment, yes.
Okay. So, Mr. Cavazos, what are we doing today?
Judge, we're here to challenge the paternity of the child, Lorraine Guadalupe Diaz Barrial. There was an acknowledgement of paternity that was signed.
Okay.
The 430th ordered a DNA test, which was done a little bit delayed. I believe there were some issues with getting the test done, but it came back in March, and it showed that the child is not my client's, and we're trying to challenge the paternity. There is another child that had not been adjudicated as the parent, but today we're here basically on the older child.
Okay, Ms. Villarreal, are you aware of the DNA results that were returned back in March?
Yes, ma'am, I am.
Okay, and are you objecting to him challenging the acknowledgement of paternity?
Yes, I am.
On what grounds?
That's not his. I mean, he knew it from the very beginning. He wanted to sign the birth certificate, and I was not willing for it, but I mean, he was there at the moment. And the other child, Bella, that is his, but I did not make a police report of how that child was made, because I did not consent to any sexual intercourse with him.
Okay, so you are objecting to him. You're objecting to it because you're stating that he signed the acknowledgement of paternity voluntarily and willingly.
Yes, and I have that all on record.
And what do you mean when you say you have it all on record?
We have videos from the hospital. My mother was there. My sister was there. So we have plenty of proof that Mr. Diaz was aware that Lorraine was not his child, and he voluntarily signed that paper.
Okay, Mr. Cavazos, are you aware of this supposed videos?
No, Your Honor, that's the first I hear of this. What I am aware of is that at the time the child was born, the child was given my client's last name, and he was under the impression, he has told me that he's under the impression that that was his child. And then there was a second child born that was not given his name, and he wasn't real sure that was his child or not.
Okay, well, it sounds like this is going, okay, so Ms. Villarreal, you will be, since you're gonna continue to represent yourself, then you're going to be held to the standard of an attorney. But Mr. Cavazos, are you wanting to even look at those videos, or do you want to see if there's even any such evidence?
Yes, Judge, and we have no way of contact. She doesn't have an attorney. I was hoping she would today. We have no way of contacting her or having any contact with her. My understanding is that this was signed on based on fraud, duress, and mistake of fact. So.
Okay, so and you also have to overcome the time period. I'm not sure yet. I'm going to give you an opportunity to put on the record as to when he signed it and when he withdrew it, and if it meets the statute with the respect to time limits. So before we get into all that, I'll give you some time. Ms. Villarreal, what is your phone number so that Mr. Cavazos, you will need to be in contact with Mr. Cavazos because you're representing yourself. So now you're making some allegations and that you're alleging that you have some type of evidence that he needs to see, because then his motion has to overcome certain things in the statute. So now he's got to look at whether or not that will be the case. And he can certainly still move forward with it once he looks over your alleged evidence. But if he's calling you, you cannot be dodging his call or anything like that. You have to make yourself available for him. Do you understand that?
And
Okay.
I have a question. With the witnesses that were there, which was my mother, my sister, and as well as other people, and his mother and his siblings were there as well when he signed the paternity test. Now, during that process, I have videos. I ran away from the valley because he was making me tell his family that Lauren was his. I was never in a relationship with Mr. Diaz. I was with the relationship of Lauren's father, which was Orlando Garcia. And he knew that, but he wanted to claim the child as his. Now, in all that process, I could not take it no more. I was under stress. He was harassing me. He was starting to put his hands on me physically and my children. So I left the valley in the middle of the night, and he popped up in the valley.
Okay, ma'am, that's irrelevant at this point, and you're already getting into some facts that possibly later. Look, if you need to speak to Mr. Cavazos, because if you have supposed witnesses there, then if this does turn into a contested hearing, you will have to subpoena those witnesses if they're going to be adversarial, okay? So if they're going to be adversarial witnesses, then you'll need to subpoena them, which means they will not be coming voluntarily. So if you don't subpoena them, they won't be here to supposedly corroborate your story. So, but you do need to speak to Mr. Cavazos about that.
Okay.
Okay, so what is your phone number?
My number is 361. Well, actually, can this be off the record for Mr. Abraham Diaz? I mean, because I have a protection order against him.
Judge, just let me give her my number and you can text me.
Okay.
956-975-8803. Text me. The first text you send me with your name.
Yes, sir.
And then just let me clarify, you said Orlando Garcia was the father?
Is the father of Lauren.
Is the father. So he's still alive and everything.
Oh, yes, he is.
Okay. Okay. Is he in the child's life?
No, he's not.
Okay.
Okay, anything else on that?
That's all we have, Your Honor.
Okay, so how much time do y'all need to confer and then have this be placed?
Judge, I would say 30 days. And Judge, is it possible to send us to a breakout room? We don't have to necessarily come back. And I'll ask my client not to join if I just need to talk to her.
Okay, let me go ahead and do that.
Thank you, Judge.
Yes, and do you see a message on there? If you can please accept it.
Or you can also send me over that with those parties as well.
Yes, and you may want to enlighten them on what I was stating about the deadline to rescind the acknowledgement of paternity.
Yes, Your Honor.
I think she froze.
Who? Oh, the lady? I don't
Yes.
know. She's fine. Okay, so moving on. And you're Elizabeth, but what is your full name?
It's Elizabeth Herrera. And I'm here for number 5 on the court's docket. Or no, wait a second. Number 8 on the court's docket. I'm sorry, Your Honor. I represent CL Moto Finance.
Okay, it's because I had Savannah Barlow. Okay. Okay, and Mr. Contreras was on the other side. Okay, I thought Mr. Contreras had already, this is on CL 193234-I. Didn't his motion to withdraw get granted?
It did, Your Honor. And looking over the court's docket here this morning, I saw that he had been in the hearing this morning, and so I was checking into it. I think we may have an issue with his order granting.
Okay, what would
It
that
looks to
issue?
me like he still may be attorney of record for defendant.
Okay. Did he not do his order granting
I
correctly?
don't think he submitted an order granting.
Oh, he hasn't submitted it yet. And I apologize, it's because there's another person just with the name Elizabeth. That's why when you started talking, I was like, well, I know that's Miss Herrera, but. Oh, that's Elizabeth Hernandez, okay.
So we're here today on my motion for summary judgment. But I think we may have an issue.
Yes. Okay.
And I was hoping that Jesse would still be on, but I don't see him still on here.
Okay. Well, what we'll do, unfortunately, because of that, I mean, usually I'll set a tickler for orders to be submitting, but not on an order granting the withdrawal. But let me ask, Ms. Rivera, you had your hand raised?
Yes, Judge, it was previously filed. For whatever reason, they filed it under 10, Court 10. The order reflects Court 10, so that may have been the reason why our clerk did not send it to us. However, we could request it and fix it for purpose of efficiency if you'd like, Judge.
Yes, because I think Ms. Herrera has also been very patient with respect to this matter. So we'll go ahead and do that. Ms. Herrera will request it from the clerk. He put the wrong court on it. So it went to another court. So we'll request it and we'll go ahead and just cross that out and put our court just so we can get it done quicker. And then I'm going to need for you to file another order resetting hearing on your motion for summary judgment and include, please, the defendant and his pro se capacity and the last known address that you have.
All right. Yes, Your Honor.
And then when you submit your order resetting hearing, we'll get you set as quickly as possible.
All right. Thank you, Your Honor.
Okay, you may be excused.
Thank you.
Okay, Attorney Diana Fuentes Aguilar.
Yes, Your Honor. We reached an agreement as to most of the terms, Your Honor. There's just one issue. If I can, I'll proffer the agreement and then ask Mr. Hernandez if that's what he agreed to.
Okay, Mr. Hernandez, can you please turn on your camera? Mr. Hernandez, can you please turn on your camera? Can you hear me?
Yes, Your Honor.
Okay. All right, then I'm gonna call F 3716-21-9 in the matter of the marriage of Elizabeth Hernandez and Marcos Hernandez. Can I please have both parties raise their hands? Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Miss Elizabeth Hernandez.
Yes, Your Honor.
Okay, Mr. Marcos Hernandez.
Yes, Your Honor.
Okay, you may lower your hand. Okay, you may proceed, Ms. Fuentes Aguilar.
Your Honor, what we've agreed to is that Mr. Hernandez will remain in the home until September 4th. My client will be able to stay there as well. After September 4th, my client will move out. I believe that the home is located at 1402 San Francisco Avenue in Edinburgh. Your Honor, Mr. Hernandez will be responsible for paying the $20,000 BBVA note, which was a note taken to purchase the property. And he also will be responsible for paying the owner finance monthly payment due on the home. He's agreed to that. Now, Your Honor, he's also agreed that Ms. Hernandez will be allowed to take her Ford Escape and she will pay for it. That he will be allowed to keep the Jeep truck that is under my client's name. However, if he's more than 30 days late, fails to insure it, or allows any of his family members who do not have a license to drive it, then my client will have the right to take the Jeep away from him. He's agreed to that. He's agreed to injunctive language that will prevent for him from harassing my client in any manner, whether by phone or texting or anything like that, and that he will not encourage any girlfriend he might have to text or harass my client as well. Your Honor, that's basically the agreement. However, there is one issue we could not agree on. We are asking that on September 4th, when my client moves out, that he be away from the home from 8 a.m. to 5 p.m. Last time she's tried to move stuff, Your Honor, there was issues and everybody was extremely uncomfortable. He's stating he will not leave the home. My client wants to get her things out. She has family coming to help her. And so we just want him to be out of the house from 8 to 5 on that day.
Okay, so do you have a list of items that she will be taking out of the home at that day? I'm sure that's what his hesitation is.
I do not at this time, Your Honor. I can ask my client if she can state, I guess, or we can submit a.
Okay.
I don't know, before September 4th.
Mr. Hernandez, why do you want to be present when she's moving out of the
That's
house?
fine, though. I'll not be there, though. Yeah, that's fine.
Okay.
Yeah.
All right. I would still suggest that you be very clear as to what it is that she's taking, just so that nothing, comes up later, but he's agreed to not be present during that time period. So let me ask you, Ms. Hernandez, is that your understanding of the agreement, ma'am?
Yes, Your Honor.
Okay, Mr. Hernandez, is that your understanding of the agreement?
Yes, Your Honor.
Okay, this is going to be put in an order that is going to require both of your signatures. So Mr. Hernandez, because you are representing yourself, you will need to make yourself available to Ms. Fuentes Aguilar to sign, okay?
Okay, ma'am. Honor.
All right. Then I'm going to give you 2 weeks to get that done and submitted. And I'll go ahead and just set a tickler for September the 10th. When does this become ripe? You're on mute, Ms. Fuentes Aguilar.
Sorry, Judge. It was filed August 11th. So maybe after October 11th?
Because I believe you stated in your petition, there is no community property other than just, or is this the only community property and it looks like it's already divided? Is that correct?
Well, except that, Your Honor, if he's not making the payments as we've expected, then we might ask for a different thing in the end. And I've explained that to him as well.
Okay.
Because my client is concerned he won't make these payments.
Okay, so then why don't we at least let the 30 days pass and see how he does, and we'll come back on October 20th for a status hearing. And if everything is good, you can finalize it at that time.
Yes, Your Honor. Your Honor, the tickler on September 10th, do you want us to appear or is it just the court's reminder?
No, ma'am, it's just a tickler for me to see if you all have submitted the temporary orders with all signatures.
Yes, Your Honor.
Okay.
I have nothing, Your Honor.
You and your client may be excused and Mr. Hernandez may be excused.
Thank you, Your Honor.
Mr. Alexi Ramos, remove your cap, sir. Thank you.
Okay, let me see.
Judge, my opposing counsel just came on.
Okay, I saw that and
we're number 28 on the docket, Judge, and we went to mediation and we have an agreement.
Okay, so was Ms. Alvarado going to be present today?
I don't know, Judge. I didn't think so.
Is she, so you have an agreement, and does that mean that, are you proving it up right now?
Yes, Your Honor.
Okay, and was Ms. Alvarado present at the mediation?
I think she was available to us by phone. Is that correct, Mr. Mendoza?
Okay, let me
he's on mute.
Okay, let me just see if she's going to come on so that I can just hear from her. that she's going to approve the agreement. If I can have somebody from my office, please contact her and see if she'll be getting on.
Judge, I think she was appointed for the child's issue. There was no issues with the child. Everything had to do with property mostly. At first there wasn't, and now there isn't anymore.
Okay, but since I assigned her, I still need to hear from her just to see that she's approving it.
Okay.
Okay, so just be on standby. So, Ms. Julissa Sanchez?
Señora, aquí estoy.
Okay, that's F 2415-19-9. Okay, Ms. Castañeda, can you please ask Ms. Sanchez if she's had contact with her husband?
Ms. Sánchez, ¿ha tenido usted contacto con su esposo?
No, ningún contacto.
No, no contact.
Okay, so then let me just look it up really quick. Now, she was to file the order for the ad litem for the publication, is that correct?
Yes, Your Honor.
Okay. Okay. Please let her know that we did receive her appointment of attorney ad litem, but it was just filed yesterday.
Ms. Sánchez, la corte recibió su orden que pusieron para el ad litem, pero apenas lo metieron ayer.
Sí, es correcto.
That's correct.
Okay, let her know that we will request it so that it'll be sent to me for my signature.
Lo vamos a pedir de enfrente de la corte de los clerks para que la juez lo firme.
¿Está bien?
That's fine.
Okay, so I do need for her to come back then on September the 15th.
Su próxima corte es el día 15 de septiembre.
At 9:30 a.m.
A las 9:30 de la mañana.
Ok, está bien.
Okay, that's fine.
Okay. And so then we'll see her at that time.
La miramos el día 15 de septiembre a las 9:30 de la mañana.
Muchas gracias. Está
Thank you.
bien. Es para finalizar entonces.
Okay. So before we move on, Mr. Cavazos and Mr. Sanchez and Ms. Villarreal, everybody is back now.
Morning, Judge. Jaime Casas here. I believe we have an agreement, Judge.
Okay, let me recall F 4922-19-9 in the interest of a minor child. Okay, and what is the agreement?
Judge, my understanding from Villarreal is that she will agree to the challenge of paternity on the older child, Lorraine.
I'm sorry, you will need to say that again because there was somebody that was not on mute. Okay, Mr. Cavazos, go ahead and repeat that.
Yes, Judge. Jaime Casas here for Mr. Abraham Diaz. I believe he's trying to sign back in. After we got in the breakout room, Ms. Villarreal is in agreement to the challenge of paternity. So we're going to be asking the court to go ahead and grant it, and we'll be turning in an order. We also agreed that the OAG is going to provide testing post-order for both of the children through the OAG's office.
Okay, just go ahead, Mr. Sanchez.
And that is correct. We do put, there are two children in this case. One has an acknowledgement, which is Lorraine, and Bella does not have an acknowledgement. For Bella, there is no objection from the state regarding DNA. There is an objection for Lorraine because of the AOP. However, we are here properly before a challenge, and based on what I heard from the parties, they are wanting to do the DNA on both children, since Mr. Diaz does not have a father figure for this child. So there has been little relationship between the child and the father. since he signed that acknowledgement.
Okay, so, but the point being that the issue before me today is the motion to challenge the acknowledgement of paternity that Mr. Dees are signed.
Yes,
So now you're telling me there's an agreement on that motion, is that correct?
yes, Your Honor.
Between the mother and the father, there is an agreement, Your Honor, to accept the challenge and order DNA for both parents, Your Honor.
We'll just submit an order reflecting what is agreed to. So that, and that order does need to be signed off by Mr. Cavazos, Mr. Sanchez of the OAG, and Ms. Villarreal, since she's pro se. So that'll tell me that you all are all in agreement with the language in the order, and then I'll sign off on it.
Yes, Judge.
Okay?
Yes, Your Honor.
All right. So submit that to me. I'm gonna give you until September the 10th. And that'll be just a tickler that I'm gonna set for myself.
Thank you, Judge.
Okay, anything further?
Your Honor, also, the court ordered the DNA for the children at this time? Or is it after so we can begin the process?
I mean, yeah, but you need to begin that process now. So I'm gonna order that DNA to be done, just so that everybody will know convincingly.
Thank you, Judge.
what
Do you
the
need me
results
to,
are.
thank you, Judge. Do you need me to submit an order for the DNA testing as well?
I believe Mr. Sanchez will need one.
Yes. Yes, Your Honor, we can do it both the order by agreement, the order challenge and the order for DNA as well.
Yes, Judge.
Okay, so just confer with Mr. Sanchez, Mr. Cavazos.
Yes, Your Honor.
Okay, anything else?
Nothing
That's all.
further, Your Honor.
Nothing further, Your Honor.
Okay, then you all have a good day. You may be excused.
Thank you.
Thank you, Judge.
Yes.
Thank you. Have a good day.
Okay, let me go ahead and, did we have anybody call in on number 2 or number 3?
Judge, from my knowledge, they were going to be submitting Rule 11s, but I'm going through the docket to see which ones were missing. They were next.
Okay, so we're gonna move on since there's, let me see.
Judge, I see Ms. Alvarado's already on there, Judge, on our case.
Yes. Okay, so let me go ahead and recall F 2847-20-9 in the matter of the marriage of Ina Zamora and Judith Ruiz Rodriguez.
Good morning, Your Honor. Catarina Alvarado on behalf of the child. I'm sorry, Judge, I'm gonna, with your permission, if I can just keep my camera off.
Yes, that's fine.
Judge
if I
Almocasa for Ivan de la Mora, Judge.
Oh.
And Robert Mendoza for the respondent counter petitioner.
Judge, as an added item in this case, Judge, it's my understanding that the parties reached an agreement at mediation regarding all issues, including the possession and access, which I haven't seen what that is, Judge, but I believe that, you know, there wasn't many issues regarding the visitation. Mom was going to be primary, and I think that's what it ended up with dad having visitation. My only issue is that I did ask for a retainer from the parties up front. I usually ask for $750 per side. I did not receive any money from Mr. De La Mora. I did receive a payment from Miss Judith Ruiz. However, Judge, I'm going to reduce the fee since we didn't go any further, and I did not attend mediation. I did not attend the mediation with the parties. My fee will be $500 per side, and I would just ask that that be incorporated in the order.
Okay, so what is the balance that Ms. Ruiz Rodriguez owes?
$250.
Okay, and Mr. De La Mora owes the 500. Okay.
Correct.
Judge, they're going to be having funds available to them, both parties, Judge, because they're going to be selling both homes. So I suggest we pay Ms. Alvarado first, or they can pay her as soon as they get their money.
No, that's too far out. How long do I know? I mean, she's already been working pretty much for free the entire case. So no, they're gonna have 2 weeks to pay her. So they need to make arrangements, and then if they want to borrow money from a family member, they can tell that family member that after they sell the home, they will pay them. So they're gonna have 14 days from today's date to pay their balance. If not, she can file an enforcement action and they'll be brought in front of me, and then they'll have to pay attorney's fees at that time. Okay, all right, Ms. Alvarado, then that's the only issue that you had for the court?
Yes, Your Honor, that's the only issue I have. And then if the court would like me to review the final order, I can sign off on that as well. I do know that they resolved all issues at mediation. So I haven't seen their mediated settlement agreement, but it's my understanding that the possession and access was agreed to.
Okay, so right now what we're gonna do is have it proved up, and that divorce decree, has that been generated yet or not yet?
Judge, I prepared that. I'm just missing a little bit of information that Mr. Mendoza is going to send to me. You know, he and I have been in contact. I'm waiting for that, and I'll add Ms. Alvarado's name for signature on the final document, Judge.
Okay, all right. Well, Ms. Alvarado, then you may be excused, and we're gonna continue with the hearing.
Thank you, Judge.
Okay, so Mr. De La Mora and Mr. Ruiz Rodriguez, please raise your right hand. Okay, do you swear that the testimony that you are about to give is the truth, the whole truth, and nothing but the truth, so help you God? Mr. De La Mora?
Yes.
Ms. Ruiz Rodriguez?
She's on mute.
You're on mute, ma'am.
Yes.
Okay.
Judge, also for the record, Judge, I think she understands some English, but she's not very fluent in English.
Okay, well, I know that I've heard her speak both, so let me ask her. Ms. Ruiz Rodriguez, do you prefer that this be in English or Spanish?
En español, sí es mejor.
Okay, then Ms. Garza, if you're going to read the agreement into the record, I ask that you do it slowly and in pieces so that Ms. Castañeda can translate it.
Okay.
Okay, you may proceed.
Thank you, Your Honor. Judge, the parties have agreed as follows, that the parents will be joint managing conservators of the child, and mom will establish the primary residence of the child with a geographical restriction to either Hidalgo County or Nueces County, Judge.
Okay, Ms. Castañeda, you can translate that. Ms. Garza is going in sections.
Ms. Ruiz, el acuerdo es que ustedes van a ser manejadores unidos de la conservatoria de la niña, y va a haber una restricción para el condado de Hidalgo y el condado de Nueces.
And that she will establish the primary residence of the child also.
Y usted va a tener la residencia primaria de la niña.
Also, dad shall have standard visitation as per the family code, which is the first, third, and fifth weekend of the month, starting on Friday at 6 and ending Sunday at 6.
Y el papá va a tener la visitación al estándar para la niña de la posesión, comenzando el primer, tercer y quinto viernes del mes, comenzando a las 6 de la tarde y terminando el domingo a las 6 de la tarde.
They will also have holidays as per the family code.
También van a tener la visitación de las vacaciones acuerdo al código del estado.
There's also a special provision that shall be included because of dad's work. Dad must give mom 24-hour notice of his intent to exercise any portion of the possession period.
Okay, también va a haber una provisión especial que papá tiene que dar una noticia de 24 horas antes de la visitación.
Also that the party taking possession of the child shall be responsible for picking up the child at the residence of the party releasing the child.
También hay la persona levantando a la niña va a tomar posesión de la niña en la propiedad de quién va a estar en posesión de la niña?
Party not in possession of the child shall have daily communication through either FaceTime, Skype, or any other form of verbal or facial communication between the hours of 6 and 8 p.m. If the call goes unanswered, the party in possession of the child must ensure that the call is returned to the non-possessory parent.
Quien no esté en posesión de la niña tiene derecho a tener FaceTime o Skype de 6 a 8. Si la llamada no se contesta, la persona que tiene la posesión de la niña es responsable de regresar la llamada.
And it can be, other than FaceTime and Skype, it could be like verbal communication also.
Y si no es por Skype o FaceTime, puede ser comunicación verbal.
Mom and dad may designate an adult a competent adult with a valid driver's license to pick up or drop off the child.
Mamá o papá pueden designar un adulto competente con licencia de manejar a levantar el niño, la niña.
Dad shall pay child support in the amount of $1,476 a month beginning September 1st of 2020.
El papá va a pagar la manutención de la niña en la cantidad de $1,476 por mes, comenzando el día 1 de septiembre del 2020.
A dad shall provide health insurance for the child, and each party is responsible for 50-50 of any uncovered medicals. The child support will be paid through the state disbursement office.
El papá va a proporcionar atención médica para la niña.
And each party is going to be responsible 50-50 for uncovered medicals.
Y cada papá o mamá van a cubrir 50% de pagos que no se cubran por el medical support.
Child support to be paid through the state dispersal unit.
Y el child support, la manutención se va a pagar por la compañía del Child Support Disbursement Unit.
Parties also agreed that there is no retroactive child support or arrearages due of child support as of August the 31st of 2021.
Los partes también están de acuerdo que no hay child support retroactivo de agosto 31, 2021.
We'll have the standard language regarding disparaging remarks.
No se van a hacer comentarios desagradables.
Also, as far as property and debt division is as follows.
Lo siguiente es lo que es por división común.
The residence located in Mercedes, Texas shall be put up for sale and split 50-50 between the parties.
La propiedad del Mercedes, Texas se va a poner en venta y se van a dividir los procesos 50%, 50%.
The mom is going to have the exclusive use of the residence in Mercedes until the property is sold and shall be responsible for all debt in association with that property. That includes all the utilities and property taxes.
Mamá se va a quedar con la exclusiva de la residencia de la propiedad del Mercedes y debe va a pagar todos los deudas que vienen asociadas con la residencia.
The house shall, I'm sorry, go ahead. The house shall be sold for no less than $105,000.
La casa se va a vender a no menos de $105,000.
If the residence is not sold within 6 months, beginning September 1st of 2020, the parties agree that the sale price will be reduced by 10%, and another reduction of 5% after the first reduction.
Si la propiedad no se vende antes del 1 de septiembre, se va a reducir por un 10%.
I'm sorry, no, that's not correct. That the beginning September 1st, the property's put for sale. And if it's not sold within 6 months, starting September 1st of 2020, then it gets reduced 10%.
Okay. La propiedad se va a poner en venta comenzando septiembre 1. Si no se vende en los primeros 6 meses, la cantidad se va a reducir por 10%.
And again, if it's still not sold within the next 6 months, then it's reduced another 5%.
Y si en los siguientes 6 meses no se vende, se va a reducir un 5%.
Also, the parties must select and agree on a realtor on or before September 1st of 2020.
También mamá y papá tienen que elegir un agente de bienes raíces para el 1 de septiembre de 2020.
Then there's another community property residence located in Corpus Christi, and that shall be put up for sale also, and the proceeds will be divided 50-50 also between the parties.
También hay otra propiedad en Corpus Christi que es propiedad de la comunidad. También se va a poner en venta y se van a dividir en 50%, 50%.
That shall have exclusive use of the residence pending the sale, and he shall be responsible for all debt associated with that residence. Pending the sale includes utilities, mortgage payments, and property taxes.
Papá va a tener la exclusiva de la propiedad comunitaria y va a pagar todas las deudas que vienen asociadas con eso, incluyendo las taxas de la propiedad.
That house shall be sold for no less than $255,000.
Esa propiedad se va a vender a no menos de $255,000.
If that residence is not sold within 6 months, starting September 1st of 2021, then the parties agree to reduce it 10%.
Si esa propiedad no se vende en 6 meses después del día 1 de septiembre de 2021, se va a reducir 10%.
And then if it's still not sold, then on the next 6 months, it'll be reduced another 5%.
Y si después de esos 6 meses no se vende, se va a reducir otros 5%.
Parties agreed that they will select and agree on a realtor on or before September 1st of 2021 for the sale of that house.
Los pares, los papá y mamá están de acuerdo que van a escoger un asesor de bienes raíces para la propiedad.
Mom, the parties have dogs, and mom will keep the 3 dogs that are in her possession, and dad will keep the 2 French bulldogs that are in his possession.
La mamá se va a quedar con 3 perros que tiene en su propiedad y papá se va a quedar con 2 perros que tiene en su propiedad.
Mom shall be awarded the 2013 Ford Fusion along with any debt associated with the vehicle.
Mamá se va a quedar con el Ford Fusion 2013 y con todas las deudas que vienen con esa propiedad.
Mom will be awarded the water softener system, and dad will be awarded the t-shirt printing equipment and supplies currently in mom's possession.
Mamá se va a quedar con el water softening system y le va a otorgar a papá la limpiadora de camisas que tiene en su posesión.
Dad will be awarded the 2020 GMC along with any debt associated with that vehicle.
Papá se va a quedar con la GMC 2020, también con toda la deuda que viene con esa posesión.
Dad is awarded the timeshare along with any debt associated with the timeshare and all paperwork associated with that timeshare, which is in the possession of mom for right now.
Papá se va a quedar con la multipropiedad asociado que está asociado con los parties y con la deuda de esa multipropiedad también.
Mom is awarded all the furniture, all the contents of the house located in Mercedes.
Mamá se va a quedar con toda la muebles que están adentro de la casa que está en Mercedes.
That will be awarded the contents of the residence located in Corpus Christi.
Y papá se va a quedar con los contenidos que está en la casa de Corpus Christi.
Each party is responsible for any and all debt in their names since date of separation.
Vos están, mamá y papá están, cada quien va a cuidar sus deudas, va a pagar sus deudas desde la día de separación.
And the debt in their names.
Y cualquier deuda que tengan en su nombre.
Each party is awarded his or her personal possessions.
Cada papá y mamá les están otorgando las posesiones que tienen en su posesión.
Dad is responsible for the IRS debt in the amount of approximately $4,000.
El papá es responsable por la deuda al gobierno por la cantidad de $4,000.
Each party is awarded any retirement account that is in his or her name.
Cada mamá o papá tienen derecho a su cuenta de retiro que está en su nombre.
The parties agreed to a mutual injunction, including harassing, threatening, or annoying language.
Las partes están de acuerdo a una orden judicial mutual de no hacerse comentarios a cada quien.
The parties agree that should a party discover an asset with a value exceeding $1,000 that was not disclosed by the other party in possession of the asset shall be awarded 100% to the discovering party.
Las partes están de acuerdo que si divulga que hubo algo ocultado con algo que tiene valor más de $1,000, será propietario de la parte que lo descubrió.
Parties agree to stipulate that there has been no family violence and no allegations of family violence in this case, and that would impede their ability to enter into this agreement.
Y las partes están de acuerdo que no ha habido violencia familiar.
Dad shall no longer be obligated to provide health insurance for mom and may remove her from his health insurance plan immediately.
Papá ya no va a estar obligado a tener seguro médico para mamá.
And basically that's the end of the agreement, Judge.
Ms. Castañeda, can you please ask Ms. Judith Ruiz Rodriguez if that's her understanding of the agreement?
Ms. Ruiz, ¿este es el acuerdo que llegaron
Sí.
Yes.
Mr. De La Mora, is that your agreement as you understand it for mediation?
Yes.
Judge, I think the only issue that I see that might arise is getting a real estate agent for them to agree. I was going to recommend Mr. De La Mora said that they had one before that had, I think they bought the house in Mercedes by, I don't know that Ms. Ruiz has an objection. The lady's name is Giselle Elizondo.
Okay, I don't know, I'll give Mr. Mendoza the opportunity to discuss that with his client.
I don't have an objection, but obviously I haven't talked to my client. I think she wants to say whether she is or not.
Okay, Ms. Castañeda, can you please, what was the name of the realtor again, Ms. Garza? I apologize.
Grisel Elizondo. That's for the house here in Mercedes, Judge.
Okay, Ms. Castañeda, can you please ask Ms. Ruiz Rodriguez if she has an objection to Grisel Elizondo selling the Mercedes house?
Ms. Ruiz, ¿tiene usted una oposición a que Grisel Elizondo sea la agente de bienes raíces para la propiedad en Mercedes?
Sí, tengo otra persona que me recomendó de la iglesia. So,
I have
me
another.
gustaría.
Okay, it sounds like it sounds like she does have an objection to that. What I'm going to state is if you all do not come up with an agreement on a person within 7 or 14 days from the date that the decree is signed, then the court can assign one if you'd like.
Judge, they need to be put up for sale by September 1st.
Oh,
So
okay.
that means we have to have an agent already. Judge, it's just that case has been delayed again and again and again, and we just like to finish it out already.
Your Honor,
I'm not faulting anybody, Judge. I'm just saying it's just been going on for a long time. We just need to finish it out.
Okay, Mr. Mendoza?
simply that was part of the agreement. Nobody's intentionally trying to delay anything, but there is an objection. She called for it and she got an objection.
The
So
thing
we
is that you all do need to agree to a realtor very quickly, because if you want it listed by September 1st, that person still needs to do the comparables as to what, if that even is a good price. I know you set a price and they will have to start at that price, and you did set forth how it was going to be handled if for whatever reason it wasn't able to be sold at that price, but the person needs to get on it, in other words.
I would suggest what the court said, but instead of being 7 to 10, 14 days out, it can be done, by the 27th or something of this month. And if not, the court can appoint somebody.
And that's fine, Judge. That's fine. The thing is, we need to move this along, Judge, because like at mediation, we brought up the name and nobody ever said anything. They just said, so we need somebody already so we can get this one over, get the house listed and get it. So my client believes that the house is worth more than that, but we want to sell it minimum at that, if not more.
Okay, so, well, I'm sure everybody wants to make the most that they can out of it. So if you all don't agree by Friday, just have it all signed. And then if you'd like, leave that blank when you submit it to me and it's forwarded, I will fill in who it will be.
Judge, and on the one, the house in Corpus, do they have an opinion as to how they want to handle that? As far as a realtor?
I would say just the same ruling.
Okay.
Okay.
Then by Friday?
I would say, because if you want to get it listed right away, so you'd have to, if you all don't agree by Friday, submit the order by Friday so that it can still have time to go through the queue and then get forwarded to me so that I can sign it, because you'll be pushing it anyway, because then you get the order back, let's say by Monday, hopefully, and then you've got to, make sure that it's accepted, and then you all have to have it emailed to you, and, so you're going to be cutting it pretty close to get somebody in there to look at it and sign you up by the 1st. So just go ahead and get that to me as soon as possible.
Okay,
so I would say the sooner you all agree to somebody, the better, so that you can get that sent to me. But if you can't, then just get that sent by Friday.
Judge, it's just that, since the mediation, we talked about this, they haven't sent us anything, nothing in responses to what they want and who they want. And we recommended this lady because that's who, they did work, they bought the house from the last time, and they didn't say anything. And I haven't heard anything from them since the mediation, and I just wanted to move it along. And the other issue that I think we might have is on the timeshare. My client gets that. Ms. Reese has all the paperwork on the timeshare, Judge, all the vouchers and all paper in connection with that. And my client needs it. If she could return that to my client by September 1st, Judge.
Your Honor, we said we would deliver that, and we're going to do that. And as far as the mediation, nobody pressed that issue. So I guess it's both parties' fault then.
No. At the mediation, we did talk about the timeshare exchange.
No, I'm talking about the realtor. And so nobody pushed the issue to be written down on the realtor. So I would suggest the same ruling or order that turn it in by Friday. And if it's not, the court appoint one.
Okay. Well, yeah, on the realtor, but I'm talking about the timeshare. She has the paperwork.
On the
For the
timeshare,
timeshare.
I emailed you and I said we would get it to you.
By when? Friday,
probably, Friday also.
Well, the thing is that it would probably have to be Thursday in all fairness, Mr. Mendoza, because that decree has to be filed by Friday.
What
And
are
you
we
all are
today?
trying to make the September 1st deadline.
What are we today?
We're the 25th.
Already. By tomorrow.
I don't see a problem, Yana. This is a matter of logistics. My client doesn't have a scanner, so we're gonna have to try and see how we can get it, because if she gets it to me, she's gotta bring it to Brownsville, and then I can send it. And
Well, Judge, she also lives in Mercedes, and we're here in Edinburgh. She could drop it off at the office to drop off the originals.
I mean, I'll allow y'all to work out the logistics of that. I mean, I'm not gonna,
Yes, of
you know,
course.
so you guys can figure that out. I'm not the one that's in a hurry to sell this house by the 1st. So if your parties are really in a hurry to get this on the market by the 1st, then everyone will cooperate and everyone will get it submitted to me on time.
Of course. That's fine, Your Honor, with me.
Okay? Okay. All right, anything else? I'm gonna go ahead and set a tickler just for me, just to make sure that I know you want this sold by the 1st, but I'm gonna set a tickler for September the 10th, just to make sure that everything is submitted to me by that date. Okay?
Yes, Your Honor.
Okay. Then I commend the parties for coming to an agreement and the attorneys, because I know that this was rather contentious and divorces are always very difficult. And I just, I commend you all on that. So best of luck on getting all of this done in time.
Thank you, Judge.
And if I may just say that the mediator did a great job.
She did.
Okay, that's good to know. That's good to know. I think, was that Ms. Diaz, Melinda Diaz?
That's correct.
Yes, Judge.
Okay, all right.
As a matter of fact, I just recommended her on another difficult case that I have.
Okay, all right. Well, I'm glad it all worked out.
Thank you, Judge.
Okay, y'all take care. Have a good one.
You too.
Best of luck to you, Mr. De La Mora and Ms. Ruiz Rodriguez, okay? Don't forget, your daughter is the one that's important here.
Thank you, Your Honor.
Okay,
Thank you. May I be excused?
yes,
Thank you.
Thank you, and have a good day.
likewise. Okay, Melissa Romero?
Good morning, Your Honor. I'm here for case number CL 19-4038-I, and that is number 19 on the docket. I'm here on behalf of Ms. Aisa Garza, who is the defense counsel of record for the defendant Elizabeth Gutierrez.
Okay, and do we have anybody on behalf of the plaintiff? Okay, so I understand the last time there was an issue, and so we had to extend it until June 30th. That has that issue been resolved?
The stay has been lifted as far as we are concerned. And I know that Ms. Garza has been in communication with her client and the carrier regarding the case and proceeding forward.
Okay, so then where are we at as far as the discovery and all of that good stuff?
I'm not sure, is Mr. Sanchez here on behalf of the plaintiff?
No, I'm here on behalf of Miss Iona Symes, one of the other defendants.
Okay. I don't see the plaintiff's counsel on here. I'm not sure exactly what else needs to be done.
What about on your end? I mean, do you know, are you all planning on taking any depositions, or where are we as far as the discovery for the defense is concerned?
We are still proceeding as forward, so there is still an exchange of discovery. And I know that Ms. Garza did submit over that documentation because of the whole receivership issue to plaintiff's counsel to turn over, since technically now TPC, which is the company has taken over ACCC, is now has the status of UIM carrier. So I think they're pending that documentation, but she is still proceeding with the discovery and the ongoing of the case.
Okay, Mr. Sanchez, do you want to add anything on behalf of your client?
No, we're just here to make sure that the case is moving along and confirm that the stay was lifted.
Okay, so then we can go ahead. Let's see where we're at in 60 days then to see if you've continued. And I'll make sure, Mr. Sanchez, not to set it up on a day after a Monday night football game, okay, of the Cowboys. You're lucky that my civil docket is on Wednesdays, Mondays and Wednesdays. Okay.
There's no Tuesday night football, I guess.
Yeah, well then don't come on my criminal day. Tuesday is my criminal day. All right, come back on October the 27th at 9:30. And if you can please see if plaintiff's counsel will be on at that time.
Yes, Your Honor.
Okay,
Yes, Your Honor.
so then we'll go ahead and see you then.
Thank you, Your Honor. May I be excused?
Thank you very much, Your
Certainly
Honor.
may.
Have a good one.
Likewise. Okay, so Mr. Gutierrez, do you know if opposing counsel was going to be on?
Your Honor, I do not know. I know
Okay.
it was Mr. Haberman.
Yes, well, we are on the docket and it's after the time and they did receive notice, so I'll move forward and allow you to move forward with your approval. So it's CL 181077-I, state of Texas, because I was talking about the Capital One Bank versus Justin James. Announcements?
Benjamin Joseph Gutierrez on behalf of Capital One, Your Honor, ready to proceed on a bench trial.
Okay, Mr. Damian, will you please call the name of Justin James 3 times?
Yes, ma'am. Justin James. Justin James. Justin James.
Okay, the name being called out 3 times and no response. Mr. Gutierrez, do you want to move forward?
Yes, Your Honor.
Okay, you may proceed.
May it please the court, Benjamin Joseph Gutierrez on behalf of Capital One. So we're asking relief from this court in a matter having to do with the contract that the defendant, Mr. James, entered into with Capital One. And it's a Visa credit card ending in 6308. As per the defendant's request and also provided previously, I believe with some of the initial filings was a business records affidavit. There's actually 2 business records affidavit that we would like to be entered into evidence for the court's consideration. It's in the, and then also entered into evidence, especially the business records affidavit from a Miss Yarborough and Miss Templeton. Yarborough's affidavit was provided on 11/18. That's when it's notarized, and then Miss Templeton's is provided on March 2018. And so if those can be entered into evidence, and then so therein it provides in the business records affidavit that there was a balance due on Mr. James' Capital One Visa credit card account, and there are statements that are provided from January 2015 all the way through September 2016. The last payment on this account, according to the statements and according to the affidavits, was on March 14th of 2016 in the amount of $300. The account was eventually charged off in September 2016, and I guess there was even a post payment on October 2017. All the statements went to a 719 Cedar Avenue, McAllen, Texas address. The defendant was served opposing counsel. Mr. Haberman did enter appearance, and we believe that these documents do show that it is more likely than not that there was a contract and there was a breach, and we are requesting damages in the amount of $20,750 plus court costs, Your Honor.
Okay, are you requesting any attorney's fees at this time?
No, Your Honor.
Okay, so the court will take judicial notice of all the documents in the court's file and will omit the exhibits that were offered by plaintiff's counsel, and will grant the relief as requested by plaintiff's attorney. Is there an order on file with this relief that was requested?
Your Honor, I had a hard time with this cause number showing up in the system, so I personally do not know. There may be, but for some reason the system wasn't recognizing this cause number when I entered it into verify.
Yes, because you're using H at the end and it transferred and it's an I now.
Well, then that would make perfect sense.
But I don't fault you because I understand your local counsel stepping in. Hold on, I have to mute, sorry. So don't worry about it. Just check if there's an order that was e-filed with that relief, and if it wasn't, just go ahead and have one e-filed before September the 10th, because I will check on the 10th to see if the order was done.
Understood.
Okay.
I appreciate your time, Your Honor. That's all I had. May I be excused?
Okay. You certainly may, sir. Have a good day.
Thank you, Your Honor.
Okay. CL 21-2070-I, Jesusa M. Perez versus Stephanie Benavides.
Good afternoon, Your Honor. Andres Ramos. I'm standing in for Renee Flores on this matter on behalf of Jesus Perez, the plaintiff.
Okay, and Ms. Benavides, I do see her on. Ms. Benavides, can you hear me?
Yes, I can hear you, Your Honor.
Okay, can you please turn on your camera?
It's on.
Yeah, for some reason you're on a gray screen. And I need to be able to verify. Okay, while you figure that out, Mr. Guerrero, was Mr. Sanchez going to be appearing today, or do you have an agreement to put on the record?
Judge, I don't know whether Mr. Sanchez is going to appear. My client, Alexi Ramos, is here, Your Honor. This is a case that at every single prior appearance, Mr. Sanchez has represented to the court and to me that they're willing to have the house refinanced because she was supposed to, when I say she, Lorena de la Garza, was supposed to refinance the home and has not been paying current on the house.
Okay, hold on, Mr. Guerrero, before I get to that.
Okay,
I have another case in front of you, but I just needed to know because he's not on. So I don't anticipate that we will take too long with this bench trial. So I just was trying to give Mr. Sanchez an opportunity to come on. He's not on. I don't know if you want to reach out to him to see if he is going to come
I'll
on.
do that,
If not,
so
that we'll proceed as soon as we finish with Mr. Ramos.
Okay. Thank you, Judge. I'll do that.
Okay, Ms. Benavides, there you go.
Yes.
Okay, Mr.
Sorry.
Ramos, do you need your client to also be sworn in?
Yes, Your Honor, we might as well.
Okay,
Is
so
there any-
is Ms. Perez understand English?
Yes, she does, Your Honor.
Okay, Ms. Perez, if you can please just click the little microphone. Is she on a computer or an iPad?
She's on an iPad, Your Honor. She's downstairs here at the office.
Okay, if you can just click on the microphone so that you can unmute.
Somebody's on their way to help Ms. Perez.
That's fine, not to worry. Don't worry about it. If it's on an iPad, just touch the screen, and at the very bottom, you should see on the left-hand corner, a microphone.
I'm sorry, Judge. It looks like reinforcements are going down.
Sylvia knows how to do it.
I'm glad you think so, Judge, but nobody told Sylvia she knows how to do it.
There's on the corner, Sylvia, if you touch the iPad, there should be on the bottom corner, the little microphone. If you'll just click it. You see where they turned on the video? Were you able to turn on the video right next to the video camera? There's gonna be a little microphone.
Your Honor, the announcement I have to make may eliminate the need.
Okay,
For
if you don't
testimony.
need, okay,
And
what?
if we-
Okay,
Well-
let me just do this. I'll go ahead and allow you to make the announcement, and then that way, if we need to, we can swear them in. If not, we'll see. So go ahead, Mr.
Got it.
Ramos. Okay, we got it. Okay.
Thank you, Your Honor. Judge, what we have here is an appeal from a forcible entry and detainer action that was filed in the JP court. We first asked the court to take judicial notice of all the filings in the case, including all the documents that were transferred from the JP court to Your Honor's court. Most notably, Judge, in the documents that were filed and all the documents that have been filed within the court's case, there is no appeal. There's no appeal bond. Now, Ms. Benavides did file her inability to pay court costs and pay bond. However, that would lead to the next step, which is doing a surety bond or some kind of supersedious surety bond, which has not been effectuated. The appeal was filed on May the 25th, 2001, and pursuant Texas Rules Civil Procedure 143A. They got 20 days to perfect an appeal, to file the appeal bond, whether that be a surety bond or whether that be an actual cash bond. Neither of those was done in this case, Judge. In such, the court loses plenary power, and we're asking the court to summarily deny the appeal, summarily grant what the petitioner is seeking, which is what the original judgment was, which was granted back on May the 25th, Judge. Essentially what failing to submit the bond does is it makes it like there was never an appeal filed at all. And that's the current circumstance. And I'd ask the court to, again, take judicial notice of all the documents that are filed, and then make a note that the lack of bond that has been filed in this case, which would render it basically an unperfected appeal, therefore unactionable by Your Honor.
Okay, so Ms. Benavides.
Your Honor, we appealed when it first went to court at the Justice Court. And then she violated that one when she came to my home with a gentleman, a big gentleman, knocked on my doors, banged on the windows, and I'm a victim of a violent crime.
You're frozen.
Attorney General scared my
Ms. Benavides,
kids.
You're frozen, like you're going in and out.
Made a report, and sorry, I think they're calling from my child's school. And now all I'm asking is that, I know that it got my CDC, I filed with CDC, I filed with Texas Renters Relief Program already. There's awaiting a list, and I've been calling every day. I have an ID number for that as well. After court, it's been about 2.5.
Ms. Benavides, we can't hear you. You are now.
Half weeks. Somebody pulled off the meter from that house. Called my. Can you hear me now? My boyfriend called the.
You're going in and out, but let me tell you, in essence, more or less where you're at procedurally. Can you hear me?
Yes, I can hear you clearly.
Okay. So Mr. Ramos is arguing that the statute requires that a bond be posted whenever you file an appeal. And if you are unable to pay the appeal bond, you are correct in that you do file an affidavit of inability to pay. However, you would still need to post a surety bond, okay? And procedurally, and that has to be done by law. There's no exceptions. There's no jumping through any other hoops. It has to be done. It's black and white, step one. And if you can't do step one, such as post the bond, then you do step two. Now, when you don't do any of those things correctly within the time frame that is required by law, which is 20 days, then it automatically is out of my hands. There's nothing that I can do. I can't hear it. I don't have jurisdiction over it other than to sign a final order so that the judgment can be carried out. So in this, I understand. So in this case, you did not post the appropriate bond, and you also didn't post a surety bond. So that means it's out of my hands. You didn't do it within the 20 days. And I understand that you've been trying. I remember that you did do the last announcement in stating that you were on a wait list and that you were trying to get some funds. And unfortunately, that hasn't pulled through. But even if it pulls through, this is now out of my hands. I can't hear it. I can't do anything other than just sign an order that reflects the judgment, which was originally ordered through the justice of the peace. And so there's, although, I can empathize with you, I can, see the situation you're in, but that she has a right.
Yeah, it's been pretty hard because somebody pulled the meter off the house. We had the right.
Hold on.
for 3 weeks.
So I understand, but unfortunately, there's nothing that I can do. And, you've come to the end of this road right now. So the judgment that is on file with the court, and that is the correct judgment, will be the judgment of this court and will be signed, because Ms. Perez does have the right to pursue this at this time. So
Okay.
I do know, Mr. Ramos, that you do have that for her to vacate the home and stand her. However, I'm hoping that you all will come up with a reasonable time to give her an opportunity to move her things out with dignity, okay?
Ms. Bettis has always been very amenable to that, Judge, and I'm sure this is not an exception to that case. I'll discuss that with Ms. Bettis, Judge, and nobody wants to see anybody out in the streets, but Ms. Bettis is, like Your Honor said, she's still the landlord. She still has her rights, and we intend to effectuate that. And I'll discuss that matter with Ms. Bettis right now, and we'll try to come up something with reasonable with Ms. Benavides, Judge.
Okay, so Ms. Benavides, that's the only thing that the court is requesting, that they give you some time. You will have to take whatever time it is that they give you, because they do have a right for you to move out immediately. However, I know you even stated on the record that Ms. Bettis has been very nice and courteous to you.
Yes.
And so I'm sure this time will be
I still
no
feel that
different.
way.
Okay.
I still feel that way.
So I'll sign that order, Mr. Ramos. I'll ask for it to be sent to my queue, and then we'll make sure that Ms. Benavides also gets a copy of it. We have as your email address stephnOam@AOL.com. If that,
Correct.
okay, so you will be receiving a copy of that order to that email, okay?
Okay, thank you.
Okay. Well, I wish all the parties the best of luck, and hopefully you all can get this done amicably, okay?
Thank you.
Okay. Anything further, Mr. Ramos?
That's all we have, Your Honor. Thank you.
Okay, you're welcome. Y'all have a good day.
Thank you.
Okay. Mr. Guerrero, any word from Mr. Sanchez?
Judge, I did get an opportunity to speak to Mr. Sanchez's assistant, and she notified me that she was going to add this case to Mr. Sanchez's calendar. I don't know whether the court's aware, but he has had prior settings, and he shows up and, but I mean, going to the heart of this case, Mr. Alexi Ramos, who's the movement in this case
Well, let me go ahead and call the case, Mr. Guerrero. Mr. Sanchez did have notice today of today's hearing. Is that, so F 3450-09-9 in the matter of the marriage of Lorena de la Garza versus Alexi Ramos. And Mr. Guerrero, and Mr. Sanchez did have notice of today's hearing. Is that correct?
That's correct, Judge.
Okay.
We all appeared at the last hearing, and you had directed us to this date, and he had also told us that he was going to have his client refinance the property because she was not paying timely on the case.
Okay, so let me have Mr. Ramos sworn in so that you can have the appropriate prove up questions
Yes, Your Honor.
asked of him so that you can prove up your enforcement action. So Mr. Ramos, if you can hear me, please get on the camera. And I need for you to unmute, sir.
Lexi, can you please unmute?
Can you see me?
Okay, sir. Can you please raise your right hand? Do you swear that the testimony that you are about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Okay, Mr. Guerrero, you can proceed.
Thank you, Judge. Alexi, can you state your full name for the record?
Alexi Ramos Araujo.
Thank you, Alexi. Now, you were married at one time to Lorena de la Garza, is that correct?
Yes.
And there's a final decree of divorce under cause number F 3450-09. Now it's I, right? It was court number 1 where she was awarded the home. You remember that, Mr. Ramos?
Yes, correct.
Now this home that she was awarded, is she responsible to make the payments as in the decree? Does the decree say for her to make the payments?
Yes.
Okay. And has she been making the payments timely on this particular home?
Now this time from I think February or March from now, she's been making the payments.
Okay. But there was a time that she was not making the payments on time. Is that correct, Mr. Ramos?
Yes, correct.
And that's why you hired me to file a motion to enforce that the requirement that she make the payments on the house. Is that correct, sir?
Yes, correct.
Okay. Now, you were asking at that time that Mrs. de la Garza, Lorena de la Garza, refinance the home located at 227 Fudge Drive, Alamo, Texas. You remember requesting that in your motion to enforce?
Yeah.
Is that a yes, Mr. Ramos?
Yeah.
I'm sorry, Mr. Ramos, we can't hear you.
Yes.
Okay, yes, okay. And are you still making that request that the judge order that she refinance that home?
Yes, correct.
And are you also requesting that if she cannot refinance the home, that she sell the home so that it can be off your credit report? Is that what you're also requesting, Mr. Ramos?
Yes, correct.
Now, have you been able to secure credit to buy yourself a house, Mr. Ramos?
No.
Now, is the reason why you're not able to buy a home is because you're named as one of the debtors in this particular home that Ms. de la Garza was awarded? Is that the reason?
So far, yes.
So far, yes. Okay, is that your answer, sir? I couldn't hear you too well.
Yes.
Okay, yes.
Yes.
So you're asking that the court, if she does not refinance the home, that she sell the home, and that way it will no longer be in your name also. Is that correct, sir? Is that a yes?
Yeah.
Okay, Mr. Ramos, then I conclude my presentation, Judge. Now I'm ready to give a summation. basically.
Okay, now I'm looking at this divorce decree. Was this divorce decree the one that was signed by the previous court on December 17th, 2010?
Yes, that's the date that it was pronounced on the 17th. Yes, you're right. Yes, Judge, and was signed on the 17th.
Okay, so can you tell me where is the page that gives that directive for her to pay the whole?
Okay.
Because I read your motion, however, in your motion, I didn't see where the page was.
The pages aren't numerated on the actual decree, Judge, and if you see the page that's numerated 16110820, it says that the wife Lorena de la Garza shall, as part of the division of this estate, shall indemnify and hold harmless the husband and his property harmless from any failure to discharge these items. And it speaks of all the debts and liabilities after September 9th, 2005. She was obviously awarded the home.
But
there's
okay, so she was awarded the home. And it states that she was awarded the following real property, which is the home. And it only gives the legal description, not the physical address of the home.
That's correct.
But in order to meet the statutory requirements under the family code for an enforcement action, such as the one that you have filed, the language has to be specific in the divorce decree as to what it was that the person was supposed to do and what the remedy would be. And if not, the judge can decide what the remedy to correct the action is. So your divorce decree that Mr. Ramos and his wife, although be it that you were not the one representing him, I don't think at that time, or unless
Yeah, Santos was representing the wife and I was.
Oh, yes, okay. So, yes, and so I do not see that language in the final divorce decree, sir.
Well, I think in an effort to enforce, Judge, we would need a clarification that she is obligated to pay that note. I mean, I think you're right in that the language isn't specific, but we do need her to have a clarification on that.
I do agree that something needs to be done with respect to this. However, I wouldn't be able to grant the enforcement under the way it's filed. I would give you an opportunity to figure out how you want to proceed procedurally so that you can file the appropriate pleadings to give you the relief that you are looking for.
I see what you're saying, Judge. I'll file a clarification request. And
Okay.
I'll amend it and I'll file and cite the parties.
Okay.
To make sure that she's supposed to pay the home. I think intuitively everybody knows she's supposed to pay, but I understand where the court's coming from to specify the enforcement.
So once you file your motion to clarify or whatever it is that you will file, just make sure that you attach an order setting hearing to this.
Sanchez's address also on it.
Yes, so make sure you do an order setting hearing. However, I cannot grant the enforcement and action that you have filed at this time. I'll leave it pending to see if something changes. But what we'll do is I'll go ahead, so I don't lose track of this case. I'll give you a status hearing on October 27th at 9:30. If you want to have your motion to clarify set for that date as well, that's fine with me.
So October 27th at 9:30 for status.
Yes, sir.
Thank you, Judge. May we be excused?
Just to ensure that everyone at least has notice, if you can assist the court by filing an order setting the
Okay,
status hearing date with the date October 27th at 9:30 and copying all the parties that will be necessary to appear on that date.
okay. And you, an order to that effect.
Yes, sir.
Okay, I'll get that to the court.
Okay, thank you, Mr. Guerrero. Okay, going back to the court's docket, Ms. Rivera, you said there was Rule 11s filed on number 2 and number 3.
Yes, ma'am.
Okay. Did they file order resetting hearings as well?
That's correct, Your Honor.
Okay, and how about number 6 and number 7?
Your Honor, no emails were provided. If you'd like, Judge, we can look further into the petition to see if there's any available numbers to call them.
Yes, because I think they were needing to submit a divorce decree to be revised on number 6.
Yes, ma'am.
And also on number 7. If we can't, then we will probably have to put them on the drop docket. Okay.
Yes, ma'am.
All right, and how about number 21?
Number 21, Your Honor, this case, there was a Rule 11 without an order resetting hearing. It was carried over. I did include, if there wasn't an order resetting filed, the court was requiring an announcement. They did get that email and no announcements were made this morning, Your Honor.
Okay.
I also did include in the email, Judge, that the court may be proceeding forward with a show cause if they weren't filed appropriately.
Yes, go ahead and do that.
Yes, ma'am.
Okay, that does conclude this morning's docket. We are now off the record.